Now in his late 90s, Ben Ferencz has a broader view than most on war, peace, diplomacy and the international legal order. In 1947, Ferencz became chief prosecutor for the United States in the Einsatzgruppen case, one of the 12 American-led Nuremberg trials held in historic Courtroom 600 for Nazi leaders suspected to have committed grave crimes, including the crime against peace.
There's no reason to glorify war. War is hell. We have to move away from the glorification that war is great and to another one that peace is great. And the UN Charter requires that. They list 10 other ways of settling disputes. Judicial settlement is one of them. Even if you lose a case, it's going to be better than war. Law, not war, because I think law under all circumstances is better than war.
It has been a decade and a half since the International Criminal Court opened its doors in The Hague. Established by an international treaty called the Rome Statute, the ICC is the only permanent international court capable of trying individuals for genocide, crimes against humanity, and war crimes
charged against him.
Klaus Kress is a German jurist and was a member of the German delegation to Rome.
Well, the significance is that the Rome Statute, as agreed in 1998, was incomplete. One very important crime, the crime of aggression, was missing. It was left undefined. And why was that so important? The whole story of modern international criminal law started with the crime of waging wars of aggression. That was very much what the Nuremberg and the Tokyo trials was about.
Before an international tribunal holding court in the former war ministry in Tokyo come the wartime leaders of Japan to be indicted as criminals.
Originally, during the Nuremberg trials after the Second World War, the crime of aggression was called the crime against peace and dubbed the supreme international crime because it contained within it all the other crimes.
So the crime of aggression is about the participation of an individual in a major illegal use of force by a state. It is about state leadership. The crime of aggression does not cover the participation of the individual low-ranking soldier in illegal military campaigns. The crime is focused towards those who actually mastermind the overall action, and that's the state leadership, the political establishment, state presidents, prime minister. It is those who are concerned by this crime.
Professor Roger Clark from the Rutgers School of Law was also in Rome in 1998 and has devoted his professional life to international criminal law.
I like to think that we're still working on a negotiation that began in Versailles in 1919 and drafting the Covenant of the League of Nations and followed through the Kellogg-Briand Pact, the Nuremberg trials, the Tokyo trials, the efforts in the International Law Commission over the years. Our failure in Rome to get agreement on a definition of the crime, but an understanding that it should nonetheless be within the jurisdiction of the court, and then of course the subsequent efforts to bring it to fruition at Kampala.
In 2010, the first review conference of the Rome Statute of the ICC took place in Kampala, Uganda. The main goal of the conference was to finally agree on a definition of the crime of aggression and the conditions under which the court could exercise its jurisdiction. Ambassador Christian Wienerwieser from Liechtenstein, then president of the Assembly of States Parties, was leading the negotiations in Kampala.
In 2010 in Kampala we managed to find a consensus on the crime of aggression, on provisions both on definition and on exercise of jurisdiction. I think it was a success that many thought was not possible, in particular because it was a consensual agreement.
Thank you very much for listening to me at 1:20 a.m. East African Standard Time. Thank you, sir.
And with these short final words, I declare closed the review conference of the International Criminal Court.
All right.
It was decided that the amendments had to be ratified by at least 30 member states, and that the Assembly of States parties of the ICC had to take another decision after January 2017 to activate the court's jurisdiction over the crime of aggression.
I think the Kampala consensus is, of course, a product of compromise, but I think it is a good compromise. I think for those who advocate a very strong regime, the compromise they had to make was to say that for the time being it does not apply to non-states parties. That was a big compromise, but I think that was inevitable. For the others who were rather skeptical, the big compromise was to say we give up on the exclusive role of the Security Council in this respect.
By now, 34 states parties have ratified, and the activation process could happen soon. However, controversies persist. Even though legitimate instances of self-defense or military action authorized by the Security Council are of course not covered by the definition, other situations are less clear. For example, just in the last 20 years, conflicts in Kosovo, Iraq and the Ukraine have generated heated arguments on what would constitute preemptive wars, humanitarian interventions, and wars of aggression.
There can be no doubt that proceedings for a crime of aggression are politically sensitive and will attract political criticism.
But in my view, the most important thing is to complete the Rome Statute, because we said in '98 the crime of aggression is one of the most serious crimes, and to have an internationally binding definition of what that crime is, because we've never had that before. So that is, in my view, the historic step.
Stefan Beriga was the principal legal advisor to the chief negotiators on the crime of aggression for Liechtenstein and is currently the deputy head of the Liechtenstein mission to the European Union in Brussels.
It took a number of states some time to then rethink the outcome of Kampala and to realize that despite the fact that each delegation did not get everything they wanted, it is still a historic compromise, and that the overall goal, the core really of this project, namely to effectively criminalize the most serious forms of the illegal use of force, that goal is actually within sight.
With 34 states parties to the ICC, Africa forms the largest regional constituency. It has outlawed the illegal use of force by one state against another in several African Union agreements. Atalia Molokome, Botswana's ambassador to Switzerland and the UN and former Attorney General, played an important role in Botswana's ratification of the Kampala Amendments on the crime of aggression.
As countries that find themselves in many respects at the bottom of the power game, as it were, I think certainly my country, as Botswana, I believe that it is important that the crime of aggression becomes legislated as part of the international criminal justice infrastructure. And I think it is for us smaller countries, the incorporation of the crime of aggression would be of great benefit, because basically we want to make sure that, power and might are not right.
Don Ferencz, Ben Ferencz's son, is an international criminal lawyer and the founder of the Global Institute for the Prevention of Aggression.
And my father, as you know, opened his case in Nuremberg, saying the case we present is a plea of humanity to law. That plea was answered in Nuremberg, but now, in the Rome Statute and in the amendments, we have a plea of law to humanity. The law is there, waiting for our ratification, waiting for us to activate it.
From Nuremberg in 1945 through Tokyo, Rome, The Hague, and Kampala, the crime of aggression is 70 years in the making. History could be made in New York in 2017.